I've previously done a number of YouTube live streams and produced various videos providing consumers with advice in relation to the holiday park industry. And most of this advice has been aimed at helping those who have been on the end of holiday park owners effectively flouting the law. What happened next was that I put pen to paper and produced legal written submissions aimed at the Competition and Markets Authority, the CMA, in the hope that the CMA would take enforcement action and effectively clean up the market. And I've done this alongside the Holiday Park Action Group, of course led by Carol Keeble, and various others. Now, unfortunately, what resulted from the submissions that's been put in by various parties, including myself, was not enforcement action. And instead, we ended up with a written consumer law guide, if you like, produced by CTSI, which of course was aimed at the park owners in the hope, I believe, that they would read that guide and stop flouting the law and, of course, start treating consumers fairly. Now, we now know that that has not worked because holiday park owners up and down the country clearly are still flouting the law. They are clearly still either misinterpreting what the law says and the guidance that it provides, and more importantly, the protections that it gives consumers, or they're just doing it on purpose. So for this reason, I have agreed with the Holiday Park Action Group to provide more advice via videos in the form of answering the key questions that consumers who are caught up in all of this now need answering. Now, in today's video, I'm looking at pitch fees and specifically when a park owner can invoke a review and therefore when they can put pitch fees up. And when I'm doing this, I'm looking at the main agreement that's used by parks up and down the country, and in this case, a particular one from Park Leisure that has been provided by a particular person who has a pitch fee license with that organisation. The specific question that he asks me is that his license agreement provides that there will be a review each year on a specific date. The date in question here is the 1st of November. And he asks me, can the park owner ignore that date and therefore invoke a review at a later date? He doesn't ask me, can they do it before? I think it's obvious they can't. But he asks me, can they do it at a later date than the one specified in the contract? Now, the park owner itself says that it can. And in fact, it says, the argument which is being made by you is that time is of the essence, meaning the review must be started by a particular date. However, the law is quite clear that for time to be of the essence, there must be compelling evidence that both parties intended the review could be triggered by that date, including that time is expressly stated to be of the essence, which it is not. We have always followed the same process. All owners have accepted this until this new argument was raised, which would amount to a change in practice for us all. We seek no advantage in the date we give notice and find that time is not of the essence in this respect. It is given well before the pitch fee becomes due, with all the information needed to understand why there is an increase and so whether an objection should be made. You have had the time you need to make an objection if you decide to do so. So, I'm of course asked, is this park owner here, Park Leisure, is it correct? Is that the true treatment of the law, or have they got it wrong? Before I answer the actual question, let's have a look at what the law actually says. When a contract provides that something must be done by or on a certain date, the next consideration is that date a fatal part of the contract? Does it form one of the contractual terms? And in law we say, is time of the essence? Hence why you've seen in the Park Leisure response, they've used that terminology. Now, for time to be of the essence is something that the courts will look at on a case-by-case basis. But in doing so, it will look at a number of things. But mainly it will look at what's the construction of the contract? What's the rest of the contract say? Does it point towards the date being a key term? Does it point towards it being a binding part of the contract and therefore time being of the essence? But more importantly, it looks at what was the intention of the parties. Did the parties intend, when they both entered into this contract, that the date in question would be something that both parties would have to stick to? Or was it just a loose arrangement? And in arriving at this conclusion, the courts will look at the language used in the contract, it will look at anything that the parties have said or done, and basically look at everything in the round to make a decision. Now, in the situation we've got here, you would also look at the Consumer Rights Act 2015. And in particular, the first part of this journey would be to look at section 62, which is the requirement for contract terms and notices to be fair. And in particular, I cite this actual part where it says, a term is unfair if, contrary to the requirement of good faith, it causes a significant imbalance in the parties' rights and obligations under the contract to the detriment of the consumer. And then, subsection 6, a notice is unfair if, contrary to the requirement of good faith, it causes a significant imbalance in the parties' rights and obligations to the detriment of the consumer. And in the situation we've got here, we've got both a term and a notice, so both of those parts apply. Now, the next part of the Consumer Rights Act to consider is section 68. This basically is a requirement for transparency on the part of the park owner in this case. And what it says is this, is that a trader must ensure that a written term of a consumer contract or a consumer notice in writing is transparent. And the next part to consider is section 69, which is contract terms that may have a different meaning. Now, this is quite common with consumer contracts where you've got a clause that some people may interpret as one way and others would interpret in another. And of course, that's precisely what we've got here, because you've got a situation where Park Leisure and indeed other park owners up and down the country are interpreting the review date clauses not being fatal, not being time of the essence, and therefore almost being a before date. We cannot review before this date, but we can any time thereafter. Whereas others, predominantly the people that are on the end of pitch fee licenses are saying, no, we believe that you've got one chance at a review, you have to do it on that particular date. In the current example, you have to provide your notice by the 1st of October, and if you don't, then it's fatal to the agreement. You cannot do the review in that year. So that's an example where you've got conflicting views. You've got a clause, a term that could mean one of two things. Now, what the law says, in this case, section 69 of the Consumer Rights Act, is that when you have this situation, the law sides with the consumer, and therefore what you must do is take the interpretation that is more favourable to the consumer. That's what the law says. So how does this all apply to the current situation? And what's my view of what the situation, what the legal position is now? My view is that the park owner's interpretation of this particular contract is plainly wrong. And I say that for three reasons. The first reason is this contract calls out a specific date for the review date, i.e. it defines review date as the 1st of November. And if the park owner's interpretation was correct, that would not have been necessary. The second reason is when you look at clause 2.1, that clause specifically refers to the review not taking place before the review date, and also calls out that the review must first be accompanied with 1 month's notice before the review date, which again is defined as the 1st of November. And I say this again, if the park owner's interpretation of this contract was correct, it would not have been necessary to call out those dates and to link back to the 1st of November. The third reason is the language that's used, and that language is very important here because it uses the word must. And when you use must, it tends to mean, or it tends to signify an obligation, not a choice, not you can do it or you don't have to do it if you don't want to, an obligation, a firm obligation on behalf of one of the parties. And that obligation here is that you must not review before the review date, i.e. 1st of November, and you must first of all give at least 1 month's notice prior to the review date, i.e. October. Therefore, my view is that the construction of this contract is clear. In fact, it could not be clearer that the interpretation that's been put forward by the park owner is clearly incorrect. Now, the only way the park owner's interpretation would have been correct would have been if the review date had not have been defined as the 1st of November. It almost looks to me that they've missed that part of the contract, this part that I'm showing on the screen now. But in any event, their interpretation is wrong. Now let's say that I'm wrong. I don't think I am wrong, but let's say I am. Let's say you can make a good legal argument to support the interpretation of the park owner. I don't think it matters, because I think that despite that, this clause 12.1 would be deemed to be unfair under the Consumer Rights Act. And this is the two sections of the Act that I've already called out on this video. The first one, section 62. That says a clause can be unfair if there is a significant imbalance between the parties. Here there would be, because if the park owner could call out a review and implement a review date at any time of year, the consumer would be at a significant disadvantage. And let's remember this, the contract goes on to say that once we provide you with notice of what we think the review is going to be, it will be implemented, in my view, on the 1st of November, unless at least 51% of the park owners get together and put arguments together as to why it should not. Well, if they can drop this review at any time of the year, that puts all of the consumers at a disadvantage, because they'll have to rally the troops together very quickly. But if, and as is my interpretation of this contract, if that review comes at the same time every year, it means all of the consumers on the park are ready, willing, they're waiting for the review to come, and they can be prepared to rally together to put their arguments together. Without that, in my view, there's a significant imbalance between the parties, and therefore section 62 engages. Now, the other section I mentioned earlier was section 68, which is all about transparency. Now, my view is that this clause 12, if the interpretation of the park would be correct, is not transparent. It's not transparent because it's unclear. Nothing in this clause says to me that the park is correct in its interpretation. Therefore, if it is, it's just not transparent. And again, there'd be a good argument to be put forward to any court to say, for that reason, for the reasons I've set out in this video, this clause would be unfair and therefore not binding. Now, finally, if the park could get over these arguments in a court, there's one final fatal blow that I believe we can throw at this, which is section 69. On anyone's view of this clause, there are effectively two interpretations. My view is that the interpretation I've put forward is the correct one, but let's say that the park could argue that there is a plausible second interpretation, which is that even though the contract says the 1st of November, it means nothing. Because there's two potential interpretations, section 69, as I've already explained, says where there's two interpretations, the interpretation which favours the consumer must prevail. And in these circumstances, it must be that if we have to put section 69 before a court, that it would favour the consumer, and therefore the interpretation of you cannot review before the 1st of November must be the interpretation which the court would go with. So in any view, any way that you look at this argument, the park is either wrong on the interpretation of the agreement, or it's wrong because the clause is unfair under the Consumer Rights Act, or because there's two interpretations, the court's going to side with consumer. Either way, the only legal position in this matter must be that you cannot, as a park in this particular case, review outside of the 1st of November. That's what the agreement says, and I think that's what will be upheld by a court. Now, coming up next, there is going to be on the screen a template letter, which I put all these arguments in a succinct way, in a very short, brief summary, and I'm saying that if you need to write to your park about this same argument, here's a template letter that you can use.